Good afternoon. I think
Okay. Good afternoon, ladies and gentlemen. Thank you very much for sparing your time to attend this East African Law Society webinar on data protection and cybersecurity. It is a very, very pertinent topic in our day and age because, as you know, technology is here, it is part of us, it has infiltrated every part and every sphere of our lives. And of course, that means even our legal profession. So that means across the board, whether a litigator, a transactional lawyer, a corporate lawyer, whatever it is, you have to deal with technology and some of its pitfalls. And that is why the organizers of this webinar deemed it fit that it is important to build the capacity of the membership of ELS as far as being able to deal with the pitfalls of technology, especially as far as cybersecurity and data protection is concerned. So today we have a very distinguished panel or a group of speakers who are going to take us through how to interact with technology as far as the digitalization of justice is concerned. That is from virtual hearings or remote hearings to data breaches and cybersecurity when it comes to us dealing with clients' data and generally our data. And that, of course, means that more or less, it means that every lawyer should become tech savvy, or every lawyer handling work for clients should, in one way or the other, become a tech lawyer. Without much ado, I will quickly just go through our panelists and their profiles. Then I'll hand over to Mr. Gordon Myers from the International Senior Lawyers Project, who have been very instrumental in helping us organize this event. So today is a collaboration between the International Senior Lawyers Project and the East African Law Society as far as bringing this training to you is concerned. No, perhaps let me go through the profiles of our speakers after listening to opening remarks from Mr. Gordon Myers. So Mr. Gordon Myers, I'll hand over the floor to you for you to make your opening remarks regarding this session.
Well, thank you, Ivan, and thanks again to the East Africa Law Society for working with us to convene this most impressive gathering. Today, we are presenting this important second session of our legal technology series on navigating legal disputes in the digital age, cybersecurity and data protection in judicial and arbitration proceedings. My name is Gordon Myers. I'm formerly the Chief Counsel and Head of Technology Business Risk for IFC, and presently Head of ISLP's Responsible Technology Initiative. So a couple of words on ISLP and RTI for those who may not have attended our first session. ISLP provides pro bono legal services in the emerging markets in partnerships with organizations like EELS that have direct knowledge and expertise in their jurisdictions. RTI itself supports technology uptake to accomplish development goals and practitioner adoption of responsible technology practices. And we prioritize working with trusted partners in the region like EELS who share our values and objectives. I wanted also to personally thank Gabriel Achaya, who heads professional development and membership for the East Africa Law Society, our valued partner. I'm sure you know Gabriel, but to reiterate, he has been a terrific partner for us in developing this program, and we are indeed very grateful. I also wanted to thank Gloria and Rumbi, on whom so much depends. Ivan, who may be too modest, is our moderator. As he said, he's a commercial lawyer with Matrix Associates in Uganda with a specialty in technology, media, and telecommunications. He's advised a wide range of digital startups and telecommunications clients. We're very lucky to have him, and I note that he's also becoming a sports lawyer for those who may be so inclined. So returning now to Yvonne to carry things forward, and I greatly look forward to and truly look forward to this session. Thank you. Back to you, Yvonne.
Thank you very much, Gordon. And yes, thank you for helping me introduce myself. I think I know that a good job earlier. My name is Ivan Ojakol. I'm a partner at Matrix Advocates, and I have a wide range of experience regarding technology practice, and I'm happy to moderate this session. But most importantly, I'm more interested in helping you guys know who are the people going to help us understand the interaction between technology and legal practice, especially as far as cybersecurity and data protection is concerned, especially as far as handling cybersecurity and data protection concerns in virtual hearings, in arbitration, among others. So largely today's program is aimed at building capacity in as far as enabling our members or the members of the East Africa Law Society get up to speed with the scope of cybersecurity risk in virtual hearings, assess the adequacy of existing legal frameworks for data protection and digital communications in the region, articulate professional obligations like Gordon mentioned, ethical practices as far as obligations of advocates, judges, and generally the whole court staff is concerned when it comes to digital justice. And also just equip us with the relevant tools to enable us be able to navigate this very, very sensitive area of practice or sensitive area of technology when it comes to our practice. So quickly, let me run through our speakers. We have 4 speakers who will speak about this subject. We have a group from Freshfields, who we are most grateful for sparing the precious time to enable us get up to speed with this area. And we have Mr. Dan Toba. Dan Toba is the head of e-discovery services for the US region at Freshfields, based in New York, leads multidisciplinary teams that manage litigation, regulatory and investigative matters, utilize the platforms such as Relativity, Disco, Opus 2, and other top-tier solutions to optimize discovery workflows. Dan is the ex-VP and co-chair of ASED's New York chapter, serves as GPMSC Law Firm Discovery Liaison, and is a member of the TRE Scholarship Advisory Board. He's known for driving performance movement improvements through technology. Dan has expanded the firm's capability, the firm meaning Freshfields capabilities, by integrating artificial intelligence into e-discovery operations. He has overseen the adoption of AI-powered document review, applying advanced machine learning and predictive coding to prioritize relevant materials, reduce manual review burdens, and improve outcome accuracy. We may spend the whole day going through Dan's CV. He's quite distinguished as far as this is concerned, but of course, when you hear things like e-discovery, that becomes very, very important, especially in this day and age. So Dan will do a very good job and thorough job as far as bringing us up to speed with that is concerned. Then we have Marta Garcia Bell. I hope I got the pronunciation of her name right. Senior associate at Freshfields, who was a member of the dispute resolution practice group and specializes in arbitration, commercial and investment arbitration. Advises major corporates when it comes to dealing with different arbitration institutions and rules, from ICSID to LCIA to ICC. Her recent experience includes representing governments and multinational companies with investments in Latin America and Europe in a variety of sectors. She's also quite experienced when it comes to governance and ESG transformation. She's quite well published in a number of arbitration journals and topics, among others. So welcome, Miss Marta Garcia Bell. So we also have Catherine Kariuki, who will help us in understanding the East African landscape or context as far as this is concerned. She's a highly sought after legal expert in the Kenyan TMT market with over 15 years of experience, and is currently a partner at a law firm called Coventry's. Has advised clients across the scope or the spectrum when it comes to TMT, from fintech to data protection to IP, among others. Highly rated by a number of legal publishing journals, like Chambers Global, Fintech, Kenya's top 100 commercial lawyers, among others. She's highly regarded and is a regular panelist in a number of our events as East Africa Law Society, and we are very grateful to have her here. We also have Miss Dorothy Ngazi. Dazi, sorry, not Ngazi, apologies for that. Dorothy is a partner and head of TMT at Hilton Law Group and the Legal and Regulatory Compliance head at Green Telecom Limited. She has vast experience in this area, from fintech to oil and gas to emerging technologies, among others. She has advised top-tier companies on data protection and compliance, including safeguarding personal data, and drafted and negotiated contracts for technology providers and digital transformation projects. She's actively involved as far as critical awareness in the sector is concerned, including collaborations with the Personal Data Protection Commission in Tanzania and other relevant stakeholders. She's also quite published in this area, and we're very grateful to have you, Dorothy, with us. So the program is going to flow as follows. So we shall have Marta and Dan taking us through the international best practices in cybersecurity and data protection for 50 minutes. And then after that, we shall have Dorothy Ndazi and Catherine taking us through the local context in the East African community as far as cybersecurity and data protection is concerned. Then we shall open up the floor to a Q&A session, and we shall then conclude our session. So at this juncture, I'd like to welcome Marta or Dan to take us through their segment of our session. So welcome Marta and Dan to take the floor.
Thank you, Ivan. Thanks for the kind introduction, and good afternoon, everyone. Thanks for joining us today. Can we go to the next slide, please? So today we will explore the key practices and standards for conducting virtual hearings, managing cybersecurity, upholding data privacy, and ensuring the ethical and responsible use of AI tools. And then Dan will dive into data privacy and security in e-discovery, because as Ivan said, he's an expert. If we can go to the next slide. Well, today our role is to equip you with practical insights and best practices. And we were going to discuss the international standards. The legal landscape, particularly in international arbitration and judicial proceedings, has undergone a significant transformation. And this has been accelerated by technological advancements and the COVID-19 pandemic. So prior to 2020, virtual and telephonic hearings were very rare, at least at an international level. But with the pandemic, however, we rapidly adopted virtual platforms for substantive hearings, and now we are addressing virtually any stage of proceedings. And after that, virtual hearings have remained, and this, of course, has brought a lot of benefits, but also has presented new challenges. So we need to focus on having robust frameworks around digital practices. And the principles that we will discuss today are not just about efficiency. They are fundamental to maintaining fairness, integrity, and enforceability in this digitally driven dispute resolution world. So there are benefits, but there are also new risks that require careful management and a proactive approach from all participants involved. So if you go to the next slide. Sorry. And the next one, please, sorry. No, the one before, sorry. Okay, thank you. So now diving into virtual hearings. We all know what virtual hearings are, and I think that by now we have all attended one virtual hearing at least. This widespread adoption underscores the need to understand not just how to conduct them, and that we will go a little bit through that, at least from the international point of view, but also all the advantages and disadvantages. And this will be like sort of a foundation for discussing the subsequent topics of cybersecurity, data privacy, and AI, which are intrinsically linked to the successful and secure conduct of virtual proceedings. So on the benefit sides, well, we all know that virtual hearings significantly reduce cost, which were usually associated with hearings such as flights, renting a venue, accommodation, printing, catering. And while attorneys' fees remain, other costs are greatly reduced. The cost related to tech setup, which was at the beginning significant, now has decreased over time because the equipment is reusable and we are all now familiar with all the applications that are needed and we already have them handy. Virtual hearings, of course, minimize carbon footprint and are very, very helpful to connect geographically dispersed parties, which at an international level is very important, of course, but also in a continent as big as Africa. And these prove very effective when we need to resolve issues that require short notice, such as emergency arbitration, provisional measures, or urgent injunctions. Functionality has significantly improved with time and experience, and now we are at least hopefully experience less technical difficulties. And virtual hearings lend themselves well to integrating with other technological applications. So that has also helped improve the quality of virtual hearings. Moving on to the next slide. While beneficial, virtual hearings also present some drawbacks that require proactive strategies to address. Probably the most known and the one that everyone has experienced is disruption caused by technology issues or failures, which can disrupt the hearing. And it's not only disruptive, but it can also have an impact on one of the parties and on the fairness and integrity of the proceedings. Connectivity issues are a main culprit, especially for crucial witnesses located in regions with unreliable telecoms. And there are a lot of cybersecurity concerns such as unauthorized persons entering the hearings. So preparation requires shorter timeframes because when you are online, your attention span reduces considerably, and you also need to adapt advocacy and presenting testimony in a virtual environment, which makes changing the style and some of the things that we used to do in person. You also need to consider different time zones and also potential limitations that may derive from the applicable law of the state or the place of enforcement. So in the next slide, you will see very briefly some recommendations for agreeing, for reaching an agreement between parties and the arbitral tribunal of judges to hold a virtual hearing. All international protocols recommend to discuss this issue as early as possible in the proceedings, and this, if possible, should be addressed before the first round of pleadings. The goal, of course, is to arrive at a mutual agreement on the most appropriate format. It can be completely virtual, hybrid, one part in person and one part virtual, or only in person. We will discuss some hearing protocols, but just so you know, there are a lot of checklists published, and you will be able to go through them later after this session. So the only thing that I want to note is that when parties disagree, they need to be prepared to argue before the judge, and to offer relevant evidence showing how a virtual hearing would assist or prejudice your client. Moving on to the next slide. Assuming that you have agreed with your counterparty to go to proceed virtually, then it's really important to establish a clear protocol. And a lot of leading bodies like the International Chamber of Commerce, CIARP, or the Seoul Protocol provide detailed guidance for virtual hearing protocols. You see the examples here. I recommend you to look into them later. These are very comprehensive documents, especially the ICC report on leveraging technology for fair, effective, and efficient international arbitration proceedings, and I will try to discuss a little bit about it later today. So there are some key areas that all these protocols address, just to give you an overview. Technical requirements, so basic standards that both parties need to reach. We're talking about technological standards, just to make sure that the hearing is held fairly and efficiently for both parties. You may also need to have video feeds, different screens, monitors, technology. Backups are really important, especially to prevent or to manage any tech failure. Then you will need to select the correct platform and also agree on an e-bundle or e-document policy. And on the next slide, you can see just some recommendations to prepare a virtual hearing. Since the hearing is going to be virtual, we always suggest to prepare your witnesses and all the team virtually beforehand, so that they are already used to the environment. And on the next slide, I just have included some of the things that you can expect and how to be effective at a hearing. So it's important to understand the environment. There will be different rooms, even within the hearing, virtual rooms, but also physical rooms. And for example, witnesses may be obliged to give their testimonies from an empty room with a camera to prevent external instruction. Or now that COVID is over, a witness may be declaring remotely, but maybe sitting in a room with at least one representative of each party to ensure fairness. you will see multi-screen setups, multiple parties, and it's important to decide on how you're going to communicate with your team internally, because probably you will not be able to exchange physical notes. So, but at the same time, using the chat of the platform that you are using for the hearing is very dangerous. So we often recommend using like a separate chat or WhatsApp. And like in-person proceedings, here at virtual hearings, you should be professional, adapt your advocacy, and maintain constant communication with the team and the judge, just to make sure that they are following all that you're saying. So, going on the next slide, I just included. Can we move on to the next slide? Okay. I just have included some things to consider. So you may consider hiring third-party services to facilitate the virtual hearing. That's very helpful in our experience, because lawyers can concentrate on the proceedings, and there are third-party providers who can help you manage the rest of the issues related to the hearing. But at the same time, you are expanding the universe of parties involved, so that will also increase risks. Then document management, everything is going to be exchanged electronically. And you will also need to think about simultaneous interpretation, real life transcriptions, and interpretation when proceedings involve different languages. On the next slide, you will find some examples of document management practices. We normally use e-bundles, which mean that we agree with the other party on a bundle that contains all the record. And we use a lot of different platforms, third-party bundling services that help us have everything in one place and be able to annotate the documents and share our annotated documents. And then we have core bundles. Core bundles are the bundles including key documents, and which are normally shared with the tribunal or judges to keep them focused. On the next slide, just a few reminders between the differences, on the difference between expert testimony and factual witnesses, especially in a virtual environment. And moving forward, okay, just, a diagram on, what to think when you are joining a virtual hearing to ensure reliability with good tech, backups, and having technical support at hand. Can we move to the next slide? These are some recommendations. I think that you will receive these slides later, or you will receive the recording, so you can just read these by yourselves. And moving on to the next slide, there are just some good practices that you need to consider to avoid pitfalls. And I would like to flag that it's really important to always, anything that happens during a virtual hearing, it's very important to flag it as soon as possible for the tribunal or the judge, to ensure the quick resolution and to protect due process rights. So this was the first, overview on virtual hearings. Now we're moving on to cybersecurity, which of course is a very important aspect of virtual hearings. Cybersecurity involves protecting internet-connected systems, including hardware, software, and data, from unauthorized access and cyber attacks. And in today's interconnected world, legal disputes are increasingly exposed to these cyber threats. So the digital nature of virtual hearings, where we have document exchanges electronically and collaboration, expanding different geographical areas, means that it's really important to protect sensitive information. And this is not only from a technical point of view, this is a professional and ethical obligation. So cyber attacks now are commonplace and are often viewed as weapons of global economic warfare. And a robust cybersecurity strategy must be built upon three interconnected pillars. The first is people. Individuals in organizations must be aware of the risks, and there must be specialized staff trained. And this is really important because human error contributes significantly to breaches. Then processes. It's necessary procedures must be in place to adapt quickly to these evolving threats, and this includes establishing incident response plans and protocols. And technology, this involves utilizing advanced tools, including AI nowadays, to protect data and systems through appropriate softwares and hardware safeguards. And these three pillars work together, because the cybersecurity chain is only as strong as its weakest link. So we need to make sure that all links are strong. In the next slide, I just included, some type of some categories of hackers, and this is, just to make you to help you understand the different kind of cyber attacks that we can find in virtual proceedings. So one type of hackers would be the hacktivists, which are socially or politically motivated. And for example, here there was this famous Lulzsec computer hacking group that claimed responsibility for several high-profile attacks, including taking down the CIA website. Then there are the state actors, which can be motivated by ideological, political, or economic espionage. And these actors are particularly difficult to mitigate against. There's a very famous case involving the Permanent Court of Arbitration, which I will discuss later. And the last type of hackers are different financially motivated criminals, which are primarily interested in commercial gain. And of course, law firms or high-profile judicial or arbitration proceedings are key targets because they possess a treasure trove of sensitive information, including trade secrets and financial data. So moving on to the next slide. Here, as I was saying, you have some of the reasons why judicial and arbitration proceedings can be targeted by cyber attacks. And on the next slide, I included some real-world examples because I thought that that's always helpful. So the first one is the Philippines versus China case. It's the South China Sea arbitration. And basically in 2015, the Permanent Court of Arbitration's website was subjected to a watering hole cyber attack. And this demonstrated how state actors can target official arbitral institutions because it was supposed the attack was supposed to come from the Chinese government. Then another example is the hacking of Kazakhstan computers network, and that was a significant incident which reportedly revealed privileged and confidential information exchange between the state and its legal counsel. And then this information, which was leaked to the internet, was used by other parties in arbitration proceedings. So this directly impacts the integrity of legal proceedings and questions the admissibility of evidence. The same happened in Libanaco Holdings versus Turkey. It was a case of cyber espionage. And there's one more case, actually, the Brazilian pulp case, which is not on the slide, but I thought it was relevant. Basically, in 2021, Brazilian courts state an award in a multi-billion-dollar ICC dispute due to allegations that one party hacked the other's servers, accessing privileged communications and expert reports. And of course, this raised concerns about the fairness and equality of arms. The case finally was resolved and the award was upheld, and these allegations were dismissed, but still you can see how this can disrupt proceedings and have an impact. On the next slide, I included the consequences, and aside, of course, from technical issues, the harm and the economic loss can be huge. There's reputational damages, and nowadays, most importantly, this area has been heavily regulated. So all of us are also facing liability under different applicable and regulatory frameworks, including data protection regimes, which I will discuss now shortly. It can also, of course, in our sector, it will involve breaches of attorney-client confidentiality, and in the end, in summing up, let's say collectively, all these consequences, it may lead to a loss of confidence in the arbitral or judicial system. So internationally, if we move to the next slide, you will see one of the main response to the escalating of cyber threats. And this is the joint ICA, New York City Bar, and CPR Cybersecurity Protocol for International Arbitration. This is a very long document, but it's very well drafted. It aims to encourage greater awareness of cybersecurity risks and to provide a practical framework for parties to determine reasonable security measures for individual cases. The protocol is not automatically binding. It applies only if it's adopted by agreement of the parties or if the tribunal decides to apply it. And while it was drafted for international commercial arbitrations, its principles are broadly applicable to and are a good starting point for domestic or investor state arbitrations and also for judicial proceedings. On the next slide, you can see the core tenets of the protocol. It is a very flexible approach. However, it's very exhaustive and complete. It champions a risk-based approach, providing flexibility to accommodate party preferences and risk tolerance. It explicitly states that it does not establish liability or create liability, nor does it supersede existing laws or regulation. The purpose is to provide guidance for risk mitigation. And there are several factors that parties can consider when determining the kind of measures that they need to adopt. And key factors include the risk profile of the arbitration, and here it can refer to the sensitivity of data, the importance and the profile of the parties involved, existing information and security practices and capabilities of all participants, the burden and costs and resources of each of the parties, and the efficiency of proceedings. And when considering the specific information security measures to be applied, the protocol just lists some important categories, and these are asset management, access controls, encryption, communication security, physical and environmental security, operation security, and information security, incident management. And as all these protocols, it encourages parties and judges and arbitral tribunals to discuss this as early as possible to make sure that since the beginning the proceedings are protected. And I suggest that you take a look at the different annexes and schedules, because these are very practical, and they provide specific protocols and checklists on how to handle data breaches, notification and mitigation steps, and it's really well prepared. So on the next slide, just a quick summary, just to quick reminders: be proactive, and make sure to address cybersecurity since the beginning, establish an early protocol, and adopt measures that are reasonable and proportionate to the specific case to maximize efficiency without imposing undue burdens, and secure service provider access. So when engaging with all actors, not only the parties and the judge, you need to consider also factual witnesses, expert witnesses, translator, or any third-party provider. You need to ensure that their access is exclusively over secure networks. And moving to the next topic now, data privacy, which is closely intertwined with cybersecurity. And while cybersecurity focuses on protecting data from unauthorized access, data privacy governs how personal data is collected, used, shared, and stored lawfully. So the regulatory landscape, as you may all be aware, is very heavy nowadays, and it has become very complex and mandatory. So we have a lot of laws intersecting different regional laws, international laws. So understanding data privacy, it's not about compliance anymore. It's also about respecting the individual rights and avoiding legal and reputational repercussions. At the heart, of course, of these regulations, you find the right to privacy, and the General Data Protection Regulation, also known as GDPR, is widely regarded as the most influential global standard for data protection and privacy. I know that in Africa, different African countries have been developing their own regulation, and Dorothy will talk about that, but I wanted to highlight this instrument because it's really important. And it's very deeply rooted in international human rights law, as you can see, the different sources where you find the right to privacy. So moving on to the next slide. To provide practical guidance for arbitration professionals, the ICA-IBA Joint Task Force developed the roadmap to data protection in international arbitration, which was published in 2022. And this roadmap offers a comprehensive overview of the principles underlying data protection rules as they apply specifically to international arbitration proceedings. It includes extensive annexes with checklists, sample language, and other practical tools to assist in navigating data protection compliance. There are 9 core principles, and these very much mirror the GDPR: fair and lawful processing, proportionality, data minimization, purpose limitation, data subject rights, data accuracy, data security and data breach, transparency, and accountability. And for your cases, this means understanding how these mandatory data protection laws applies to each participant throughout the proceedings life cycle. And on the next slide, I included a checklist for counsel. So managing data privacy effectively requires a proactive and structured approach. And as always, try to start at the outset of the case. Consider the data processed, identify all types of data which will be involved, especially personal data, which is sensitive, or refers to criminal offenses, likely be processed proceedings, data flows. This is really, it's important to conduct like sort of a data mapping to understand where data is located, if any data will be transferred and from which jurisdiction to which other jurisdiction, and if there are potential limitations. And then try to determine which obligations apply to each participant, considering territorial, material, and temporal scopes. So here, consider which legal ground you will have to process activities. Normally, it's legitimate interest, and here it would be resolving disputes efficiently. But that requires a preliminary legitimate interest assessment. And just so you know, the concept, trying to have consent to process personal data between all parties is generally very complex and not recommended. For data transfers outside, for example, or with the European Union, European parties, but outside the European Union or other relevant jurisdictions, it's often useful to use the standard contractual clauses to make sure you know that you have a lawful basis. You need to notify the data subjects on how their data is processed and their rights. You also need to implement appropriate technical and organizational measures to protect personal data. And this goes, of course, back to cybersecurity. And again, very related to cybersecurity, if there is a data breach, you need to develop a protocol early so that when a data breach happens, you include clear notification obligations within restrict timelines. Under the GDPR, it's 72 hours. And it happens. And in my arbitrations, I have had, over 20 international arbitrations in my life. And I have experienced 2 data breaches. So, and it normally comes from either the state, because some arbitrations were against states or state-owned entities, or through the arbitral institutions. So that's why it's really important to establish all these measures. Moving on to the next slide. Of course, the impact on proceedings is huge. And you need to be aware of all the obligations that everyone has, and how especially important is how the data protection laws can significantly restrict the document disclosure or the submission of disclosure, because some parties may invoke their rights under data protection laws not to disclose certain documents or information. So these considerations are vital for to maintain due process and ensure the enforceability of decisions. And on the next slide, you will see some practical considerations. Identify all participants, as each may have distinct data protection obligations. Prepare a written document at the beginning of the proceedings. It can be the terms of references, first procedural order, or a protocol. And this sets clear expectations from the outset regarding the lawful basis, information security, data breach notifications, and document production. Address also how data protection may impact disclosure of documents and information, and develop the protocols that I was talking to you about. And I suggest looking at the ICA documents, both the cybersecurity protocol and the data protection roadmap. And going back, circling back to cybersecurity, be aware that these two areas are very closely related. So last but not least, next slide. Here you have the ICC report, Leveraging Technology for Fair, Effective, and Efficient Arbitration Proceedings. This is one of the documents that I mentioned at the beginning when I was talking about virtual hearings, and I really liked it because I think it's very comprehensive. It covers effective case management, integrating cybersecurity, data privacy, and confidentiality as crucial elements from the start of the proceedings. It provides guidance on the electronic exchange of communications, exhibits, and other submissions. Explores the use of various technologies, including e-briefs and machine learning AI, and this was published in 2022, so of course now it's a little bit out of date when it comes to AI, but it gives you a really good framework and principles, and addresses specific issues related to virtual hearings. So I recommend you to take a look. And moving on to my last topic, and this is going to be shorter. Ethical and responsible use of AI tools. We have seen that AI tools present unprecedented opportunities, but also significant ethical challenges. And on the screen, you can see some of the most famous cases where lawyers submitted pleadings with invented fake case law. So it's really important to balance the potential for enhanced efficiency and quality and the risks related to the use of AI tools. AI, just to have a general idea, refers to machine-based systems that perform tasks commonly associated with human cognition, such as understanding natural language, recognizing complex semantic patterns, and generating human-like outputs. Legal practitioners are already deploying AI in very different ways, including legal research, editing, proofreading, translations, transcriptions, generating briefing notes, summaries, management, reviewing evidence, etc. And just to bear in mind, there's also regulation coming from the European Union, the EU AI Act, and it has classified AI systems used in judicial and arbitral proceedings as high risk. So that's why, that's another reason why we need to be very careful when using AI tools in judicial and arbitration proceedings. On the next slide, you will see some soft law instruments regulating the use of AI, which have been adopted in the past 2 years. These have been adopted by different organizations, and the first two are so the Silicon Valley Arbitration and Mediation Center guidelines and the CIARP guidelines consider all actors involved in arbitration proceedings and cover different topics. And the AAA ICDR guidance and the SEC guidance is more focused on the arbitrator's use of AI tools. And if you go on to the next slide, I included the main principles that you will find in all of these documents. So these are the overarching principles for the AI use. All participants must familiarize themselves with the AI tools uses, limitations, biases, and risks, including issues like hallucinations and the black box problem. Safeguard. AI must comply with obligations to protect confidential, privileged, and secret information. And we're going back here to data protection and cybersecurity. So only secure tools should be used, and redaction anonymization applied where appropriate. While it's not always mandatory, it's been discussed whether the use of AI by counsel or by arbitrators or judges needs to be disclosed. There are different sort of approaches to this issue, but it may be required, especially if the use of AI may impact the process or influence the decisions, and this is to ensure transparency and integrity. Human oversight is really important. All AI outputs must always be critically evaluated and verified by a human. AI tools must not be used to falsify evidence, compromise the authenticity, or mislead the tribunal or judges, guarding against deep fakes and manipulated content. Arbitrators or judges using AI must not delegate their personal mandate on decision-making responsibilities. So basically, AI is a support tool, not a replacement for judgment and analysis. AI also must enhance fairness and due process and avoid in the inequality of arms. So maybe one part is using AI and the other part isn't, so that's not fair. And the use of AI, if possible, must be transparent, and and this means explaining how the AI is used, its limitation, and its impact when in proceedings. And finally, always consider the interplay with the law of the seat, the institutional rules, national laws of each party, and the ethical rules when deciding whether to use AI or not in proceedings. And with this, I leave the floor to my colleague, Dan Torba.
Thank you. Thank you, Marta, and thank you for having me on this panel. I promise I will be a lot shorter. Let me see if we can see the slides. Okay, perfect. Thank you so much. So before I dive into data privacy and security and e-discovery and anything really related to the data, I just want to quickly set a stage and talk about my role at the firm. So I mainly, in my day-to-day, deal with e-discovery. I do lately deal with data breach responses quite a bit from a technical perspective. So just to be clear, I'm not a lawyer, I'm a technologist. And it really also in my day-to-day, I work on anything that the lawyers touch in terms of the data coming in and out of the law firm. So what is e-discovery? So when I started in this industry 20 years ago, it was called litigation support and mainly dealt with the paper. As we all know now, paper is pretty much gone. And we added E to e-discovery, so made it electronic discovery. And discovery is just basically finding anything and preserving, collecting, reviewing, and producing ESI, which is the electronically stored information, to be used in legal cases. And this applies to legal, traditional discovery concepts, and basically now in a digital world, we don't produce paper. So just to kind of add quickly to this, it doesn't have to, e-discovery doesn't have to be data that's collected for production purposes. It really, and in my day-to-day, what I really do a lot with the teams is essentially make sure that they have data available to them for the review and to preparation for arbitrations, for trials and responses to the clients, and maybe even solving issues for our clients. Okay, so that was the e-discovery. So now, why does privacy and security matter in an e-discovery? So as I mentioned, we had paper, now we have discovery in the digital world, right? So we're going to have very large volumes and sensitive data. And mishandling that data can lead to regulatory value, penalties. So Marta mentioned GDPR, which we deal with quite a lot with the European colleagues, CCPA, which is a California privacy laws. HIPAA is another one that we kind of see a lot as well, and we have to ensure that everything and all that data is protected. And if we do not do and take privacy and security seriously, we will have reputational damage, loss of work product, missed deadlines. And a lot of our deadlines are for our productions, for example, to our government, which we cannot miss. So now, privacy and data security. A lot of this will be repetitive what Marta was saying, because everything that we do deals with data. And so when I look at data privacy, I always think about working with lawyers. And then when I look at personally data security, it's more of an IT information security group. However, both of these teams work together. So to just give you a real life example, if we were to use AI on a case, I will have to reach out to data privacy group for them to analyze the tool to ensure, for example, there's no AI hallucinating, right? Giving you false information. Marta gave you a few ChatGPT examples on the prior slides. And in the same conversation, I will reach out to information security group to ensure there are safeguards that prevent unauthorized access or potentially even have leaks and data breach. So it's the protection mechanism with your data, not as much the legal damages. Okay, next slide. Yes, thank you. So as I mentioned earlier, there is a lot of overlap when it comes to security and privacy. In a law firm, again, I will have to work with privacy programs and security programs to implement our tools to be used on a client's data. So again, privacy programs will define policies, lawful data handling, address consent, retention, ethical rules. So retention of data, how long do we keep the data? Do we keep it forever? Do we need to destroy it? Do we need to change? Do we need to change any protocols in place when it comes to handling our clients' data? Do we have to return it back to them? And in the security programs, we want to make sure the encryption is in place where there is now unauthorized access to the data, easy unauthorized access to the data. Can it be hacked, essentially? Next slide, please. So when it comes to vendor platform engagement and risk and solutions, right? So the most important thing these days is, and Marta also mentioned this, we work with a lot of providers. So there's a lot of data being outsourced, not only by our clients, but our internal clients as well. So making sure you are working with a provider that is reputable in the industry, has all the certificates in place that are needed to ensure the data does not leak and it's protected. So some of those security requirements that we hear a lot, ISO 27001, privacy, which deal with privacy regulations like GDPR and HIPAA. We recommend doing ongoing monitoring of vendors. And why do I say this? I mean, in the news, I'm sure you hear about this a lot these days. AI has changed so quickly. There is so many new features being added to the platforms. We want to ensure that we are staying on top of our providers to ensure that the privacy and security measures are in place and catching up with the technology evolvement. Next slide, please. So I've mentioned e-discovery. It's the ESI handling of data. There's a lot of workflows when it comes to e-discovery, and you want to ensure that legal hold, identification, collection, processing, review, production, and archiving of data is all handled in a secure manner for our clients. We do not want to over-collect data in litigation, for example, where we have unnecessary data that we host on our servers, therefore opening our clients to data breaches or security implications. We want to use advanced e-discovery platforms in our litigation. So we typically work with Relativity. We work with Disco quite a lot as well. Those are some of the platforms that are well known in the industry. And why e-discovery platforms are important. So to give you an example, if a document review is needed for emails, let's say you had 1,000 emails, you do not want to keep them in your inbox. You do not want to keep them on your local desktop. There is a potential to, change the metadata, so data about the documents, or have a data breach. Someone could get into your laptop. You can accidentally reply to an email in your inbox that you're reviewing for another case. So usage of e-discovery platforms is very, very important, and making sure you're working with reputable providers that do this on a daily basis, and that's their business. Next slide, please. Okay. So driving AI, we hear about AI a lot. Driving AI efficiency and a use case defined, not technology. Is not use case defined, is technology defined. I want to say this again because there's a lot in the news these days that AI will replace humans. I personally don't think so. It's really just a toolkit in a tool belt that we'll be able to use to kind of do our work in a more efficient way, and maybe have a little bit more free time, hopefully, to do some other things, right? So I just want to this slide is a very nice slide. I really love, because it gives you an idea of the tools that are available and what they do, right? So for example, in our law firm, we use a lot of productivity, which we call baseline tools. And those are tools you likely are using, like ChatGPT, Microsoft 365 Copilot, which is like a Q&A type of a thing, which is slightly replacing the searching that you typically would do in a Google. So you can have a conversation, a little bit more natural language conversation, and asking questions to get answers to some of your problems. I come in mostly in the legal tech space. Legal tech space, e-discovery. I've mentioned Relativity, Opus 2. We see a lot of tools here that will help you manage vast amount of electronic data that needs to be reviewed and understood by our lawyers. And then integration tools, which are proprietary work product, are tools that a lot of big corporations, as you can see here, will allow you to use and develop on top of these tools to kind of solve some specific problems that you might have in your day-to-day work. Next slide, please. And this is just to kind of bring everything together and illustrate what I was saying. So general productivity tools will be those summarize the document, long document. I don't want to really read 300 pages. Maybe I can get 1 page kind of quick summary. Generating drafting of emails. I don't know about everybody on this panel, but I personally would like to sometimes use Copilot to generate an email, and then I will adjust it to my style of writing. Legal task. Again, this is where I come in. And to kind of bring the e-discovery thing together, it's the document review in e-discovery. Right now in e-discovery, we have a lot of AI talk, right? Can we use AI, generative AI, to help us understand the documents quicker, therefore reviewing the volume of documents in the platform in a different way. So those tools are kind of coming to the market. They're already here. We're still waiting on a lot of governmental approvals, core approvals on how to use them in an ethical and secure way. And again, case-specific ones will be something that you will develop on top of some of the tools that, like, for example, Amazon Web Services and Microsoft will offer to you as a firm. Next slide, please. Okay, closing. Practical takeaways and Q&A. So the top 3 reminders I like to just point out here quickly is to confirm all vendors meet your firm security requirements. And why do I say this? There's a lot of tools and startups up in a space these days, right? So you want to make sure they have at least the standard certifications and can deal with your data in a secure way where there is no issues breaching. There is no issues with compliance and regulations, right? The second one is define scope of responsibility clearly. When you hire a provider, you want to ensure they can offer the services you are signing up for, including timelines, escalating procedures. You want to have this clearly in your contract so there's no confusion and lost control, and therefore ballooning the cost of mandates. Maintain transparency and communication. This one is again important with changing technology. There's a lot of different features that are being added to the platforms very, very quickly, and we want to ensure that what we have in a contract, what we are used to working with, and the new features are covered under the existing contract and are secure in a manner that is not only good to our internal but also to our external clients. And I think with that, I will pass to my next panelist. Thank you so much.
Thank you very much, Dan and Marta. Very brilliant discussion. Just for purposes of housekeeping, whoever has a question, there's a Q&A section, so you can post your questions there so that we can be able to address them after Dorothy and Catherine's presentations. So you can post your questions there, and our panelists should be able to answer them. Thank you very much, Marta. Interestingly, I've been participating in a couple of virtual hearings, and these are things I've not been paying attention to as far as data protection is concerned. So there are some major takeaways for me there as far as that is concerned, and clearly from Dan's presentation, and perhaps shall dig into it further later. It's important that clearly law firms are becoming institutions beyond just advocates and lawyers. We need to, in as much as possible, create synergies with IT professionals, among others, so it can be able to deliver the best services for our clients. So without much ado, let me hand over to Dorothy and Catherine. I think Dorothy is going to give us the data protection and cybersecurity context from Tanzania's perspective. Then Catherine will come in from the Kenyan perspective, or even beyond the rest of the continent. Thank you very much. Dorothy, the floor is yours.
Thank you very much, Ivan, and thank you so much, Martha and Dan. It was a great presentation, and I was very, very pleased to know that East Africa is not far from the rest of the world when it comes to virtual hearings. And some of the things Martha had already touched on, so I might not repeat so much. And as Ivan said, I will also touch base on Tanzanian context, while Catherine will touch base on Kenyan context, and I think that will be it. And as it's been stated, virtual hearings are now an established part of dispute resolution, even across East Africa, and they increase access to justice, they reduce costs, and of course, they introduce serious data protection and cybersecurity risks. And like the rest of the world, since COVID-19, we've had so much increase and rapid digitalization of court systems. Next slide, please. Yes. So in virtual hearings, we process and transmit sensitive personal data and case data. We talk about evidences, witness testimony, legal strategies, identity of documents. So poor security or weak data handling practices may cause a lot of breach of confidentiality, unauthorized disclosure, and that is why now in East Africa, like in many jurisdictions, we have data protection laws or draft laws in other countries and general cybercrime statutes, meaning both procedural fairness and statutory compliance, they're supposed to be met. And in the East African market landscape, next slide, please. Yes. In the East African market landscape, we see there's a growing demand for secure digital justice systems. This is increased adoption of virtual hearings and digital case filing, and there is a rising need for secure and standardized ICT platforms across courts. Of course, there is also expanding market for legal tech and compliance services. There are opportunities for law firms, consultants, ICT experts in data protection compliance, cybersecurity audits, digital evidence management. And then there's an issue of cross-border collaboration, the regional data flow and multi-jurisdictional litigation drive harmonization. Currently in the East African market or in the East African community, there is no harmonization and the flow is not as smooth. So kindly, let's go to the next slide. Generally, the applicable legal principles, we have data protection laws, and in most countries in East Africa, like Kenya, Uganda, Tanzania, Rwanda, we have enacted proposed data protection laws. However, there are some countries which do not have the laws, and the laws insist on lawful processing, purpose limitation, data minimization, and security measures. Also, we have cybersecurity laws. They criminalize unauthorized access, and many countries also we have these laws. Another law to be considered are evidence and procedure rules. As in virtual hearings, rules must preserve the integrity of proceedings. And then there's confidentiality and privilege. This also needs to be taken into account. And contract service provider obligations. When third-party platforms are used, contract must specify security liability, data ownership, and things like that. As we can see, Kenya established its Data Protection Act in 2019, and there's a supervisory authority there. And then there is Uganda, it established in 2019. There is a supervisory authority, as well as Tanzania, which established its Data Protection Act in 2022. We have a Cyber Crimes Act 2015, and we have the supervisory authority, which are two authorities jointly. And then we have Rwanda, which established the law in 2021. And there are other countries, they're still emerging ICT and privacy policies. And as you can see, generally, the countries are still trying to catch up with the new laws and to catch up with the data protection laws with the rest of the world. With Kenya and Uganda being the first one to be in action in 2019. Also, next slide, we have regional instruments like the Malabo Convention on Cybersecurity and Personal Data Protection and the EAC Digital Transformation Strategy 2020-2023. And these instruments are mainly the ones which guides East African countries in the virtual hearings. Next slide, please. So we have core risks in virtual hearings. Things like, I think Martha touched on this, things like unauthorized access, recording and redistribution, data leakage, weak identity verification, loss or manipulation of digital evidence, and then we have a cross-border transfer issue on how data is stored in foreign servers, and insufficient audit trails. So these are the risks in the virtual hearings. As I say, Martha touched on them. I don't have to go so deep on them. And the obligations of courts and practitioners. Next slide. Also, Martha touched on it. As in, we have to ensure the courts and practitioners have to ensure technology platforms, they're secure. We have to verify identity before and during hearings, maintain confidentiality, limit data collection, retention. I will not repeat on this because they are already touched on. And then we have the best practices. Next slide. Then the best practices. Sorry. We have the best, yes, before hearing, like what should be done, during hearing, what should be done after the hearing, what should be done. We have things like approved enterprise-grade platforms, circulating hearing protocols with data security instructions, and test sessions for technical readiness. And then during the hearing, to verify identities on record, to restrict screen sharing and recording permission, to maintain a log of participants and activities, and after hearing, to store records securely, to delete temporary files and logs, and to report any data breaches promptly. So these are the things that needs to be done before, during, and after the sessions or the virtual hearing sessions. So, of course, there are persistent gaps and challenges, next slide, in East Africa. Like, we have fragmented regulatory enforcement across countries. You'll see, I'll speak on Tanzania case and Catherine will speak on Kenya, but in each country there's fragmented regulatory enforcement, and then there's limited technical capacity in courts, there's weak cybersecurity culture among practitioners, and then cost barriers to adapting advanced tech tools. And then there is a need for harmonized cross-border data transfer mechanism, as we've already spoke before. Now, next slide. I'll come to Tanzanian context of the legal framework for virtual hearings. And we have a legal foundation as it is governed by the Judicature and Application of Laws, Remote Proceedings and Electronic Recording Rules of 2021, Government Notice number 637, that is made under Section 4 of the Judicature and Application of Laws Act, Cap 358. And mainly they apply to both civil and civil proceedings in the High Court and subordinate courts. So this is pretty much throughout the court systems in Tanzania. And they may, on their own motion, the courts may, or by application by a party, direct proceedings to be conducted remotely. And we have three systems that we use in Tanzania. We have the judiciary video conference system, that is the approved platform. And then there's teleconference, or the electronic exchange of documents through the judiciary case management system. So usually we use the electronic exchange of documents, as in the filings and everything is done through this case management system. But if it comes to hearing, well, the judicial video conference system, it's the approved platform, and that is the one that is used. So, and in Tanzania, the judiciary prohibits the use of unauthorized video applications so as to ensure a controlled and secured system. Also, remote hearings are warranted when a party or witness resides outside jurisdiction for security or health reason, or where there is necessary interest of justice. So still, it's not a thing that is done on a day-to-day basis, but depending on circumstances. Next slide. And we see that these rules emphasize on security, privacy, and integrity of remote proceedings. So we have Rule 7, 11, 17 to 19, and Rule 20, which generally they allow virtual hearing. Like in Rule 7, there is an assurance that there has to be safety, physical and psychological well-being, dignity, and privacy of parties, representatives, and witnesses. So the law tried to put in place so that there is ensured safety of the parties and especially the witnesses. And then there's prohibition of unauthorized recording, publication, or broadcasting of proceedings without the leave of the court. And then there is a provision for electronic recording, storage, certification, and official custody of proceedings to ensure accuracy and authenticity. And of course, there is electronic signing and sealing of judgment and orders is allowed. And right now, you can go through the judicial system in Tanzania. You can just upload the pleadings and you can get the judgment online, something that was not present previously. So I can pretty much confidently say that in Tanzania right now, this judicial system that is called JCMS is working pretty much well, from the primary court to the Court of Appeal. The pleadings are filed online, and all the rulings and the necessary orders are also done and received through this system that is secured, and it's authorized by the judiciary. Next slide. So we can say that the judiciary pretty much controls the approved audiovisual equipment and platforms to maintain data integrity. And then there is remote proceedings assistants that are appointed to verify identity, to test system security, and to prevent use of unauthorized recording devices. And of course, as I explained, there's access to electronic court records that is strictly regulated. Only authorized parties may obtain certified copies with fees and approval of procedures, because actually you have to have your own login credentials. So the only person who can access the court records in the system is the person who has the login credentials. So there is security, I can say it is well secured. Next slide. Yes, and from the observant of it, the laws or the rules, they pretty much integrate with the personal data protection law, which just was established in 2022. Whatever that is provided in the data protection law, these systems ensure that they are there and they're provided accordingly. For instance, they secure storage and processing of data, protection against unauthorized disclosure, accountability. And Tanzania judiciary has codified framework balancing digital access and judicial integrity. So data protection is embedded in the procedural rules, emphasizing confidentiality, control technology, and secure handling of digital records. And I can confidently say that this system has pretty much tried to ensure that cyber security threats are taken care of, as well as the data protection rules. They are governed and they are well taken care of. Practical obligations and recommended controls, we've already spoken about that, so I cannot again speak to that. There's identity verification, evidence integrity, confidentiality, data minimization, and retention, and these all are covered with this law or with these rules. Next slide, please. Okay, so I try to look at a comparative insights, and I will prompt Catherine because I know that she'll come to cover on Kenya context, but I'll go to the comparative insight before she comes to the context of Kenya, whereby Tanzania and Uganda are the countries in East Africa which I can say 4 more judicial enacted rules, specifically governing remote hearings, not just administrative directions. And with Tanzania, we've seen that there is GN number 637 of 2021 that has detailed procedure, privacy, and security controls. Also in Uganda, we have Judicature Visual Audio Link Rules of 2021, which focus on access and fair trial. And then Kenya and Rwanda really they rely on judicial practice directions and ICT-based systems that are supported by strong data protections law without detailed procedural rules for virtual hearings. And of course, on cybersecurity, the focus varies. Like Tanzania explicitly restricts unauthorized recording and defines secure storage, Rule 11 to Rule 19. While on the other hand, it depends on general data protection and cybercrime laws for enforcement. Also, we have integration with the data protection law in all the countries, at least the 4 countries, because those are the main ones which have at least certain laws that are governing. They've enacted or they've adapted modern data protection frameworks like we have Kenya 2019, Uganda 2019, Rwanda 2021, and Tanzania 2022. The rest of the East African countries, like I've said, they're still in process of making sure that they are having laws in place. And then we can talk about regional convergence as the East African communities are moving toward harmonization under the East African Community Digital Transformation Strategy 2022-2032. It encouraged standard ICT justice systems, regional data protection norms, and secure cross-border data exchange. So this is the comparative analysis that I can pretty much say that in East Africa, in summary, this is it. Next slide. Another one, next one, I've already spoke about this. Next, yes. So this is the case for Tanzania, whereby from the statistics in 2021, we had 17,979 cases which were heard using virtual proceedings. And in 2022, we had 12,243 court sessions conducted countrywide using virtual court facilities. And the effect of it is that in 2024, we had a backlog of cases that had dropped from 10% in 2023 to approximately 3% by April 2024. So you can see how effective the virtual proceedings or the virtual hearings is in Tanzania, at least. And we've seen before we had so many cases, there was a lot of backlog cases. Cases were not moving. So the virtual hearings actually has helped dropping of the backlog of cases drastically. I've not gotten the date of 2024, but I'm sure the drop is, again, it has increased. And we can see that the court and the judicial system are trying as much as possible to make sure that the virtual hearing is practical in all courts, from the primary courts to the Court of Appeal. So let me invite Catherine to speak about Kenya and conclude. Catherine?
Hello, good afternoon.
We can hear you perfectly well. Proceed.
All right. Hello and good afternoon, everybody. I'm going to pick up from where Dorothy has left off. And I will do as much as possible to build. My talking points are basically building on what the previous presenters have provided. And I will stick strictly to the Kenyan context, just giving everybody the Kenyan context of what has been happening when it comes to cybersecurity and data protection, in judicial systems, administration of justice, and what I'd call ADR in the Kenyan context. So just to give you, to build on to what Dorothy has provided, to give you a Kenyan context, in Kenya, our mobile penetration rate is about 80% of the population on smartphones. And according to Communications Authority records, 48% of Kenyans are using the internet. So what that means is there is a high mobile and internet penetration rate. And obviously, this is what I'd call was the foundation for the courts around between 2012 and 2016. That's when the judiciary and the courts started thinking around, digitizing the court process. And then when COVID happened, obviously we know the disruptions that happened, and we took it even a step higher and transitioned. So the basics of our conversation when it comes to data protection and cybersecurity, as Dorothy pointed out, we have our constitution, the act in our constitution, Article 31, which guarantees privacy, and then our Article 35 of the constitution guarantees access to information. So then out of this, that's how we ended up getting a framework that is supported by the Data Protection Act, and we have what we call the Computer Misuse and Cybercrimes Act. The Data Protection Act was enacted in 2019, while the Computer Misuse and Cybercrimes Act was enacted in 2018. This formed the foundation of how data, personal data is handled in Kenya. And, the basic concepts like data minimization, purpose limitation, lawful processing is expected to be adhered to. And our Computer Misuse and Cybercrimes Act, what it did is, obviously, it criminalizes things like unauthorized access, interference, and provides recourse for breaches. So this forms the foundation of the context that I'll give you from Kenya. So as I mentioned, around 2012 to 2016, the judiciary in Kenya came up with what we call the Judiciary Transformation Framework. And it came up with an ICT strategy. Obviously, this was pre-COVID. So then the aim of the judiciary at that time was to embrace technology and to enhance access to justice and efficiency. So it started playing around with the issue of digitizing court records so that for easier access. And before that, we had things like, if a court registry, let's say, bans, all the records are, disappear, and you have to do what we call the file reconstruction. But from 2016, that became a matter of the past, because now the courts were fully digitized and people were able to access records digitally. Then COVID happened. And when COVID happened, again, another transformation happened when it came to delivery of justice in Kenya. And the judiciary now came up with what we call the Judiciary Information Management System, or in Kenya, as we call it, JIMS. And this was the result of a partnership with Microsoft. And they were able to now, provide what we call, so to speak, secure and, enterprise grade Teams deployment like we have in our various offices. So this meant that for practitioners, for the lawyers, and also for the people who are subject to the cases in court, then everybody was now able to plug into this secure platform and access. If you look at it, when there were big wins when it came to what we'd call access to justice gains. So in Kenya, we always look at it like around that period is when from 2012 is when we had the biggest leaps when it came to access to justice gains. Because remember what I've said about our mobile penetration rate. It has meant that now litigants can attend court processes from, say, marginal areas or rural areas, while before clients would have to wait and get updates from lawyers, because lawyers would attend open court. But now what they do is they access the link is sent to them, a unique link is sent to them, and they're able to access the court hearings. And obviously it improves in a great way transparency, since clients can see their lawyers in action. So that has been a big leap in the Kenyan space. When it comes to the cybersecurity aspect, over time, and this has also been adopted on the sidelines as the judiciary is adopting this on the sidelines. Also, when it comes to ADR or alternative dispute resolution, that this has also been adopted where virtual proceedings has been enabled, and like they've also been able to come up with, like the NCIA in Kenya, they've been able to also come up with virtual hearing guidelines. So also on the ADR aspect, it's been implemented as well, even as I focus on the judiciary aspect. So all the common thing with all these, all these platforms that have been adopted, they've come up with what we call virtual proceedings practice directions. Like in the judiciary, there's one, and even NCIA, there is one. And obviously, part of these proceedings practice directions is, there are expectations of things like cyber hygiene, access controls, audit trails, and like in Kenya, judges. Judges are entitled to, they can mute you, they can remove parties, they can ask parties to exit for deliberations, and this has really enhanced the technical and organization measures that are required in the back end. So in Kenya, we have what we call the Supreme Court Virtual Proceedings Practice Directions, and these are expected to be applied by all courts. And then we also have what we call the Chief Justice Directions that were enacted in 2020. And what this did is they operationalized the e-case management system that was already there. And I already mentioned that the NCIA and JAMS, they have the virtual hearing guidelines. And these guidelines, the common thing is they stress consent, confidentiality, and secure file transfer. Something interesting in our market, in order to uphold data protection and these cybersecurity requirements, something unique is when it comes to criminal cases in Kenya, those are not held virtual, and I've said hearings. But when it comes to mentions can be held virtually, but criminal proceedings have to be in person. And therefore, if your criminal courts they all have open court hearings, and mentions can be held virtually. And obviously, this is from a human rights aspect. And we always find that that's a really good consideration that the judiciary considered. Also, when you find things like when it comes to sensitive matters like children's matters in Kenya, most likely you'll find that the hearings will be also held in open court, apart from exceptions, only exceptions where the parties have agreed and the judge assesses the situation, then you'll find that in that case, they can be held virtually. And you'll find that in that case, the other lawyers who've logged in, you'll be asked to exit the platform, and therefore you'll find the judge trying as much as possible to apply the strict confidentiality requirements and privacy requirements. While you'll find that in the commercial courts, it's quite flexible and hybrid. Most of the times when there is an open court requirement is because, say, one of the lawyers or counsel has insisted on an open court hearing. So you'll find like personally, if it comes to like cross-examination for obvious reasons, you'll find I prefer to have open court hearings because there's a consideration of, you also want to see other factors when you're cross-examining a witness. So in that case, you can ask the judge whether the hearing can be held in open court as opposed to virtual. But commercial court is where it's quite flexible. And as I mentioned, now it's become like a matter of practice that mentions in Kenya are routinely virtual. And obviously there's advantages that come with it. Let me mention a bit about the downside, which I think the other speakers had also mentioned. The downside of this having virtual hearings. Obviously, there's an element of ethical conduct and bar responsibility. And I'm sure this is not unique to Kenya, because we've had situations where the judiciary has flagged unprofessional behavior during, virtual sessions. I won't go deep into what has happened, but these were the things that came up over time, and I'd say it's a double-edged sword, and some of the things came out. But what the judiciary has done over time, what the bench has done is they've called, when such situations arise, they've oftenly called on the Law Society of Kenya, or LSK, to enforce decorum under the Advocates Act, because we have the Advocates Act that governs lawyers in Kenya, so that professionalism, applies equally online as it would in open court. And then what I'd mentioned as a sideline, so we have the Judicial Service Commission in Kenya, and in March this year, they suffered a breach in their system, and the breach exposed details of removal of 7 judges in Kenya, and the content that was accessed illegally was used to submit some things during the proceedings. So that was an interesting thing for us, and we're still watching to see how that will be handled, because as much as the private practice is, or I'd say the private sector is held to a very high standard when it comes to any breach to their systems, any data breaches, it seems that the public sector, the same standards are not quite applied to the public sector. Yet you can see, like in this case, for a breach to happen and personal data is accessed, very sensitive personal data is accessed regarding judges. We expected it to be held with the same weight that our regulator handles data breaches by other private sector people. So we're waiting to see that unfold, and we're watching that space as data protection practitioners in Kenya. But what it did for us is, as practitioners, one of the things we highlighted is that particular matter revealed weaknesses in access control and audit processes by the public sector. And obviously, it underscored a need for, one of the things we were pushing for is that they need to do DPIAs and also assess their systems. And the results made public for the public to see what technical safeguards have been put in there to provide, to protect the public's data that they hold. Maybe the other thing that I'd like to highlight is and emphasize is the aspect of ADR in Kenya. As I said, as the judiciary is making its leaps, on the other side also all the ADR processes and institutions also have made leaps and have come up with their own guidelines on how things can be done. So an arbitrator can sit in one city in Kenya, while the other party can be in Hong Kong, the other party can be in Nairobi or South Africa, and arbitration proceedings happen. And the emphasis, the bottom line about all these guidelines that have been put out there in Kenya is the same thing: emphasis on technical safeguards, organizational safeguards, and data protection safeguards and security, encryption, restricted access, confidentiality, storage limitations, and things like that. So that's common in all of them, and is cross-cutting. So in short, what I'd say is Kenya's experience just shows cybersecurity and data protection enable justice delivery, but it using technology to dispense or to enhance justice delivery is a double-edged sword, and Kenya is not unique to the global trends that are happening out there when it comes to disruption of technology and the things that come up with technology. So then we are always, you can tell the country is always trying to put in efforts to enhance so that the benefits are realized for leveraging on technology all the time. And there are various efforts across the board on sustained investment in systems and training and governance. So that's all that I'd like to cover on my end, to add on to what Dorothy provided, and to cover it with, to just emphasize what Dorothy provided. East Africa tends to like really move at the same pace. Just if one country, say, adopts one new law enhancing a particular aspect or a new policy, then the others tend to follow suit in a few years or a few months or the same years. And then you find we're moving on the same pace, so that the Tanzania situation is very closely related to the Kenyan situation, to the Uganda situation, and the Rwanda situation. We tend to move as a block. And thank you very much for your audience. And I'm looking forward to the Q&A session so that we can engage further. Back to you, Ivan.
Thank you, Catherine. Unfortunately, I'm not seeing any Q&A, which becomes a problem when you're a moderator, because clearly you have to ask a question by force. Okay, I'll start with my question, which hopefully both Dorothy and Kathy can answer. And that for me revolves around East Africa and the fact that as compared to the European Union, which is more or less more integrated than us, we seem to be, yes, Uganda, Kenya, Rwanda, Tanzania could have laws, but we are more than those 4 countries. What are we going to do about cross-border data flows in as far as ensuring that everyone is on board? And because largely multinationals, those corporate companies play around the whole region. So that is the question that you should answer, and how we can go about that, since we don't really have an integrated framework right now. Then my second question, hopefully both of you can answer that in about 2 minutes. Then my second question will go to Martha for her to tell us about her experiences as far as examination of witnesses is concerned. I mean, you're not seeing the witnesses' demeanor. Yes, you talked about cameras and what have you, but there could be ways of breaching that in terms of, say, someone somewhere coaching a witness in order to answer. So I'll be interested in knowing how you've gone about that, and whether there are any, you could have answered this in your presentation, but also just to pop up, perhaps just to emphasize how lawyers can navigate that. So I'll start with Kathy and Dorothy, then we shall go to Martha. Hopefully 2 minutes of answering, then we can wrap up.
Thanks, Ivan. I think as East Africa, I have to say, in the last 2 years, we've seen a lot of activity from the EAC Secretariat. To be honest, I think they're really trying a lot in terms of trying to enhance the digital policy from an East Africa community level. So I expect to see way more activity in them pushing for harmonization, so that as a bloc, we are really moving at the same pace, so that when it comes to cross-border controls, there's the ease of doing business. And then on the other front, like Kenya, we're currently, we've already started our process of sending to the Malabo Convention. And part of the Malabo Convention requirements is for us to harmonize our cybersecurity and our data protection frameworks. So then, and Rwanda has already done that. So if you look at it, at the end of the day, if all East African countries are able to really assent to that, it means we'll be on the same page, and it will make doing trade easier. Doing trade and also the cross-border control. There's also the other aspect of, as I mentioned, we tend to mirror each other as East Africa when it comes to enacting laws. And all of us borrowed, I think, heavily from EU GDPR. So most of our, say, data protection laws really mirror EU GDPR. And the advantage of that is we tend to have the same laws. I've also seen a lot of activity from our regulators in East Africa. I don't know about you, Ivan, and I'd like to hear your comment on this, Ivan and Dorothy. But I've seen a lot of more collaboration and between our regulators in those 4 countries, because again, as you said, when I talk about East Africa, I always leave out Ethiopia, because I feel it's a different, and Burundi, it's a different ballgame altogether. But the other 4 countries tend to move as a block, and I've seen a lot of engagement between our regulators when it comes to the data protection space. So I'm hoping that I'll see a lot more of that and then come up with MOUs and agreements and to just enhance the ease of doing business. On the issue of cross-border, had mentioned, like in my presentation, I mentioned, so like in Kenya, for me, and I know other lawyers, we prefer when it comes to cross-exam, I'll always request for me to do cross-exam in open court, even if it's a commercial matter. And the courts are usually very understanding in Kenya for that. The judge will rarely ever push back and say that the hearing has to be done in person. And the judges tend to move with the pace of the people. Like if you request even for your witness, instead of your witness doing giving the evidence in virtually, for them to do so in open court, the courts are usually very accommodative. And so it's common practice that we rarely do cross-exam virtually, almost always, unless in exceptional circumstances, for instance, where my client is out of the country and can't make it here in good time, then in that case, I'll opt for the virtual hearing. Thank you. Back to you, Ivan.
Dorothy, Dorothy's take us on the same quickly.
All right, so as Catherine has spoken, the 4 countries, that is Kenya, Tanzania, Uganda, and Rwanda, they're almost moving together. And if I'm to speak specifically on the cross-border data transfer on the virtual hearing, yes, virtual hearings always involve cross-border data flows, because if one person is not in the country and then you're having a hearing, obviously there'll be cross-border data flows. And in each country, I believe in the East African region, they have their own legal framework to manage this, and it varies from country to country. Like in Tanzania, the Data Protection Commission will require to approve any data before it is transferred outside the country. So in case there is any transmission of data between outside Tanzania, be it in the East African region or any other outside that, the requirement is that the commission has to approve that flow of data. So if we're talking about the virtual hearings, the cross-border data transfer is a hindrance, because in each of the East African countries, the laws are different. Every local country has their own structure on the movement of data, and it's almost impossible to have information transfer between one country to another. And then if you're having a hearing, practically in Tanzania, you cannot have a virtual hearing just without any code. So we're so certain that in most cases we have these virtual hearings. You can have one person maybe outside Dar es Salaam, if you're in Dar es Salaam, maybe in up country. And then when it comes to cross-examination or hearing or examination, obviously there's a need to transfer data. But if it's in country, it's way easier. But if a person or if a witness is outside the country, the situation gets more complex. So in my opinion, there's a need to harmonize or to look for a way to ensure that justice is access to justice is increased by harmonizing the cross-border data transfer in our countries, particularly in East African countries, because pretty much it's not easy to move data outside Tanzania, for instance. And for each transaction, for each moment that you need to move data, you need to get authorization from the commission, the PDPC. So you can have, like the judiciary, you can be having multiple information that needs to be transferred for a case of virtual hearings in a day. This has proven to be difficult in other organizations. So I can see it could be a problem also, and it is a problem also even in the court systems, because if you have multiple data to be transferred and the time limit, because now you have to move from the judiciary, from the court, you have to go to the commission, seek approval. Of course, it's done online, but you're talking about a number of days there which are being wasted, and the procedures and everything else. And I can say cross-border data transfer is a hindrance to some extent in ensuring that we get access to justice, and the virtual hearings or virtual proceedings are done smoothly. I know certainly that this is the case in Uganda also, because the Act permits transfers where the data subject is consented. Ivan, you're from Uganda. You can say more on that, and there are adequate safeguards. So it's not just automatic that you can just transfer data outside one country to another country. So courts and practitioners need to be conscious of where the hearing data is done, like the video recordings, the documents, witness testimonials. How are they stored? How are they transferred? How secured are they? So this is a whole other thing that needs to be looked at, so as to ensure that there's no breach of privacy or of data privacy in the process of the virtual hearings. Thank you.
Thank you, Dorothy. Martha, unfortunately, we've gotten 2 questions at the end. I don't know. The ELS tell us, do we have more time to address these questions? Because they've come at the end. But Martha, you can go ahead and have your take on that.
Just very quickly on cross-examination, we have had a really good experience during COVID. We usually send all the witnesses a very comprehensive IT kit, which included several screens and different, headsets and everything, and a 360 degrees camera. So with that, we would have, and the tribunal also would have a camera showing all the room and all the space where the witness was sitting, and while they were testifying, we could see that no one was interfering, no one was doing anything. Curiously, I have had worse experiences when we were in person. For example, we had this time where a napkin fell from a witness's pocket, and it had written down some things to say. And now that we are more in a hybrid world, and that people can sit in the same room, when we have a witness cross-examined virtually, what we do is that we send one representative of our team and one representative of the other party's team, and they sit together with the witness while they are declaring, and that's the way that we ensure that nothing irregular is happening.
Okay, fantastic. Just to perhaps answer Dorothy. Dorothy, Uganda has the same provision. I think the adequacy standard. If we had export or have personal data moving out of our border, it should be to a country that has the same level of safeguards. In other words, a country, for example, the data protection legal region. And that's why I was asking about East Africa, because not all the countries have them. So, yeah, now we have a challenge here. And Gabriel, I request for 5 more minutes. I don't know if you can answer those questions in the Q&A, because to be very unfair to our attendees if you don't, but if they have come late. First question goes to, I think these are both Kenyan specific questions. Clearly, Catherine is going to answer them. How do you balance the need for access courts by members of the public and the need to restrict admittance to ensure security of virtual courts? For example, in Kenya, in some courts such as employment and labor relations courts, is open to anyone, while the Court of Appeal, it is restricted to the parties only. That's interesting. Is that really a data protection issue, or it's an administrative issue by the courts? But you answer it kindly in the next 1 minute, hopefully. Catherine. Then I'll answer both. Then the second one is, in Kenya right now, what carries more weight, data protection certifications or a law degree with regard to data protection roles?
Okay, so with regards to the first question, I think it's safe to say, obviously, the efficiencies that are introduced by, access to justice, and the transparency issue when it comes to digitization of the court processes and being able to access virtual hearings, the benefits are higher than what I'd call the cost. And yes, one of the costs, and we've had several issues here and there, where the courts hadn't perfected restricting admittance of some people. So we've had situations where, for instance, when the process started, some people were able to access a link, let's say in a children's matter, but you're able to access the link and you're able to access the court hearing for a children's matter where, and that is a matter where if you were in open court, all of you would have been asked to leave or the matter would have been taken in chambers. So over time, people were able to access that. But I have to say in Kenya, like you keep seeing the judiciary, they've been trying to like improve this, like even, especially in this, what we'd call the sensitive matters. I'd say that that is where they started. But in commercial courts, I still see that happening a lot as well. People accessing a matter, for instance, the counsel who is in the next matter is admitted early before a certain matter is completed. And, because there's no guarantee that there aren't private and sensitive and confidential issues that will be discussed in the previous matter. And I know advocates in Kenya have brought this up quite a number of times. So I've seen the courts administratively, especially the courts clerk, trying to address this and only admit you during when your matter comes up. And I've also seen guidelines being issued to us lawyers to also try and adhere to that. And yes, I believe that's one of the things. It's a teething problem, and that's one of the things that should be improved. Perhaps maybe more stricter guidelines should be given to us. But we'll see how that goes. But obviously the benefits outweigh the cost, in my opinion. On the second question about the data protection certifications, I'd say I always tell people that it's an add-on. So obviously a legal or a law degree is important, and then the certification is an add-on, which is good because then it means you're in terms of your technical capabilities, and it also helps. For instance, if you're going to be hired as a DPO, if you're going to be a data protection expert, obviously I'd expect the basics for you to have some data protection certification, since it's an emerging law. Some of us in university, we didn't have a course on data protection because we didn't have, we did a little bit about confidentiality, but then we didn't have, very courses dedicated to data protection and privacy. Perhaps now maybe they're there, but the laws have come later. But it's always a good add-on to keep getting these certifications to just enhance your expertise and skill. Back to you, Ivan.
Okay. It's interesting how lawyers are always trying to ring-fence areas by creating new certifications for everything that is emerging. Okay, thank you very much, my panelists. It's been a fantastic, illuminating, and all the great words, all the English superlatives to describe this session, because I think our audience, our attendees are not going to be left the same, and hopefully we can leave here better lawyers, better tech lawyers, and just better lawyers to our clients. Importantly for me, my major takeaway is that we should be proactive from the start as lawyers. We should, it seems to also be a multidisciplinary approach. It's no longer just a lawyer thing. Where possible, as a lawyer in your law firm, have an IT professional like Dan or a person of that caliber to help you serve your client when it comes to these very technical things. I think it was Martha who mentioned people, processes, and technology. And so generally, there's a lot at stake in this day and age. So please let us get up to speed in order to protect our reputations, in order to protect our clients' sensitive information, and to avoid regulatory problems that Catherine mentioned earlier, regulatory and ethical and professional problems. So at this juncture, I would like to hand over to our organizers and our hosts from the ELS, East Africa Law Society. So Gabriel, kindly close the remarks.
Thank you so much, Ivan, for that wonderful piece of moderation there. To you, our esteemed panelists, Catherine, Dan, Dorothy, Gordon, Rumbi, and the entire team from ISLP. On behalf of the East Africa Law Society, on behalf of our CEO, Mr. David Sigano, and our President, Mr. Ramazan Abubakar, we would like to thank you for your wonderful partnership in offering a series of capacity building sessions in the month of October. It's not only been inspiring, it's been captivating, and I can see from the tone of questions that participants have asked the nature of interest that they have on this subject matter. So we are really glad to be doing this with you, the entire team at ISLP. And colleagues, be on the lookout for our next session next week that will be coming up, and hoping to host you all once again. Please be reminded that our annual law conference and general meeting of the East Africa Law Society, dubbed ELS at 30, will be taking place in Addis Ababa, Ethiopia, from the 26th of November to the 29th of November. So if you haven't yet registered for the conference, please visit our website at ellawsociety.org and do register. Otherwise, we wish you all a very lovely afternoon, and goodbye until we meet again next week. You can now exit at leisure. Thank you.
Thank you.
Thank you.
Thank you, Gabriel.